Product liability is the area of the law in which businesses can be held liable for injuries that result from defective products. In order to understand why we have product liability lawsuits, let's take a brief look at legal history prior to the Industrial Revolution. In the good old days, people lived more sedate, less complex lives. If you bought, say, a sword, you probably purchased it from the local blacksmith shop. Buyers and sellers tended to have better information about each other. This is called information symmetry. This means that if the old blacksmith did bad work, you probably knew about it and took your business to a new blacksmith. The controlling legal concept is called privity, which means that a contract cannot confer rights or impose any obligations except upon the parties to the contract. As a result, the only person who could sue over an injury caused by a product was the person who actually purchased it. In other words, it was tough being an innocent bystander. At common law, this was a strong rule that often resulted in harsh judgments. Judges hate to overrule prior decisions, so they started making lots of exceptions to the rule of privity. The problem is that the world grew more complex faster than judges could make exceptions. Privity was this wall that very few third parties to a contract could overcome. Under privity, you could sue only the party with whom you made the contract. In the good old days, you brought your bread from Rupert, your boots from Nigel, and your armor from Giles. In most cases, the retailer was also the manufacturer, so if you got sick off Rupert's crumpets, you probably knew who made them and who to sue. But what about today? Well, look at your smartphone. There may be a dozen companies involved in the manufacturing of your phone. So if something happens, who do you sue? Your carrier, the manufacturer, the subcontracting company that actually built the defective part? This more complex world has led to new protections for buyers, both through consumer protection laws and the increased opportunity to bring lawsuits. For instance, privity is no longer a requirement in order to bring a lawsuit. This allows you to bring a negligence lawsuit. But there's a big problem with negligence. In order to prove your case, you must show that the manufacturer's actions fell below their duty of care to the customers. But what if the company states that they were following standard industry practices? In the past, many courts held that companies following these standard industry practices were meeting their duty of care. So the company won, even if the standard industry practices were ill-conceived or just plain stupid. To address these problems, courts developed a new type of lawsuit based in strict liability. Under strict liability, the company is liable if the product is defective, even if the company was not negligent in making the product defective. An economist would say that strict liability causes the manufacturer to internalize costs associated with the defect that they would normally externalize. The manufacturer will anticipate lawsuits and increase their prices to cover these costs. In other words, the cost of the defective product passes from the injured party to the manufacturer to their customers. When you buy the new smartphone, a little bit of money is going toward paying for past and future lawsuits. As a result, today is much easier to bring a lawsuit involving defective products. So the next time you encounter a defective product, breathe a sigh of relief. You have product liability law on your side.